Alex here with a legal nuts and bolts video on claim preclusion, which is also known as merger and bar. This is one of two species of res judicata. The other one is known as issue preclusion, which is also called collateral estoppel. I did a video on that one a long time ago, and I'm surprised I never got around to doing this one. I think it's because most of my audience is high conflict child custody. Most people are into that series, and issue preclusion applies way more often in high conflict child custody cases. Claim preclusion doesn't apply at all, but it's a thing, and I'll explain it in a second. I don't know if I talked about what res judicata is generally, so I'll just go ahead and cover it again. The doctrine of res judicata is basically a principle that's the point of it is that when people go to court and their issues are resolved, they're not supposed to be able to, or they're not supposed to have to come back to court again in the future and address those same issues. The point of it is that people go to court one time, get it done, and that's it. It's done. It's settled. It's over. It's not supposed to be one of those things where you keep bickering over the same issue over and over again. I feel like that description, it's not very illegal at all, but it kind of gives people the idea as to what the whole point of res judicata is. And it's a pretty big legal doctrine because people, lawyers and judges, don't really like to litigate the same thing over and over again. That's the whole, there's so many cases and issues to resolve. Once an issue is resolved, it's time to move on. The court, I talk about this in the video, Overcoming Lies, Moving Forward. The court, for the most part, moves forward. You can't get it to go back, with some rare exceptions. For example, winning an appeal. If you win an appeal, you will get to go back and have that issue that the judge screwed up on corrected. But other than that, with a few other teeny tiny rare exceptions, the court moves forward, and that's the nutshell version of what res judicata does. I'm trying to avoid getting too technical, but I'm not sure that I'm not gonna be able to avoid that. So anyway, as I mentioned, that whole principle that I just mentioned, it has there's two species. I don't know why they use that word, but the Supreme Court of Nevada uses that word. They say there's two species of res judicata. Anyway, I'll go ahead and post the case so in case somebody wants to read it for themselves, because it's actually pretty educational. I think it's pretty on point, and you can see where they use that word. By the way, the case is University of Nevada versus Turkanian, but look down in the description and you'll see the link to it. Anyway, the two species are issue preclusion, which I already covered in a previous video, and claim preclusion, which I'll go ahead and cover now. Claim preclusion is actually pretty simple, but as I mentioned before, when it comes to technical issues like this, you're going to have to do your own research and look into your own state, because there's all kinds of nooks and crannies and weird exceptions that may be different in different states, and I really don't like to cover them because even if I get them right, they can change. But I will at least say that it's a thing, and that, here's generally how it works. Generally, it works like this. Once somebody files a lawsuit and the case is closed, it's over with, whether they won or lost, merger and bar or claim preclusion will trigger. And what it does is it blocks that person from bringing up anything that was just addressed in that case and anything else that could have been addressed had it been brought up. So it won't just extinguish the right to return and relitigate an issue that was just addressed. It'll also extinguish the right to come and litigate any other issue that had occurred up to that point. It doesn't block you from suing the same person on something new that they do in the future, but anything that that person or company has done to you at that point or going back into the past can no longer be sued on. It basically closes all of those doors. There are a couple of oddball things that might apply in different states sometimes. For example, I think that some states will also extend this principle to the defendant. So what I think is that in certain states where a defendant has a right to file a counterclaim, if they don't file a counterclaim, or if they do file a counterclaim and they don't address all the issues that they want addressed in that claim, they just sue for a few things, in those different states, that defendant can also not bring a new lawsuit for anything for anything that has occurred or happened to them from the date of that lawsuit and into the past. So of course, same thing with the defendant. If something happens to them in the future, they're allowed to go ahead and sue that plaintiff again if they really want to. But anything else, the doors are closed. I don't think this is true in all states. I think some states will allow a defendant to just sort of sit on their, I don't want to say sit on their hands. Some states will allow a defendant to just sort of not file a counterclaim and then hold on to that claim, whatever it is that they were thinking about suing on, resolve that case, whether they win or lose, and then maybe someday in the future they can go ahead and file a new lawsuit against that plaintiff. But some states don't allow that. At the point that you are sued, you have to consider whether or not you can file a counterclaim. And if you can, you either file it and address the issues, or you just let it go, and that's it. You've waived your rights. I don't know any further details and quirks as to how claim preclusion works. I never used it in any of my cases. I can give you at least one example that I found odd, but now makes sense to me. When I sued a landlord a long time ago in district court, I ended up settling with the landlord, and one of the things that were in the that was in the little settlement stipulation that bothered me initially, it said something like neither side can sue anybody for anything else that's occurred up to this point. And I was like, why is that in there? It's just kind of weird to me. And the lawyer said that it's pretty standard and he wouldn't explain any details to me. At this point, I really didn't know a whole lot about what was going on in the system, the legal system. But now, having learned about claim preclusion, it makes sense to me. All that thing was, all that language in the stipulation was doing, it was just codifying what claim preclusion would have done to me anyway. Once the case would have settled with that landlord, I wouldn't have been able to sue that landlord for anything else, unless, of course, the landlord did something new to me in the, sometime at some point in time after that stipulation was entered. But it's basically claim preclusion triggering and saying, this case is done, you guys have settled, it's over, and anything else that you guys could have addressed or brought up, you didn't do it, so that's it, it's gone. You should have done it if you wanted to or if you cared. You didn't sue on anything else, this is all you sued on. So that's it. Claim preclusion triggers, and it just blocks that person from coming back in the future and filing a lawsuit on something that they could have brought up to the court's attention at the time of the original lawsuit that was brought up way back when. I don't know if this makes any sense. I hope it didn't get confusing. These issues can get really technical, and as I've mentioned in other videos, the best way to sort of get your head around it is to do your own research and read a bunch of cases and look into statutes where it applies, if it applies, and stuff like that. With that, I'm going to go ahead and end this video, and I'll see you guys next time.